Kini ang sibiyahan sa RPN, Radio Philippines Network Incorporated, ang maumaong teleradyo dinhi sa amihanang Mindanao. Sa kanunay ang among dakong pagpasalamat sa inyong makanunayong pagsunod o pagsuporta sa mga programa niini nga tiunay, kasaligan, makahuluganon ug mahigalaong mo serbisyo sa tanan. Sa matag adlaw inyong makita ang sibiyahan sa RPN sa Channel 5 sa Cable TV ug madunggan sa DXKO 1368 sa AM band. Mas gipalapdan pa karon kay makita na ang mga programa sa Facebook page sa DXKO Studio ug sa RPN DXKO. Adunay audio live streaming sa website sa rpnradio.com/dxko-studio na nagpasabot nga pwede madunggan ang atong pagsibya sa mosunod nga mga provincial stations nationwide: RPN Iriga, RPN Dipolog, RPN Cebu, RPN Baguio, RPN Pagadian, RPN General Santos, RPN Bacolod, RPN Davao, RPN Zamboanga, RPN Surigao, RPN Batak ug RPN Cagayan de Oro. RPN DXKO Teleradyo, ang radyo ronda dinhi sa amihanang Mindanao, sakop sa KBP, kapisanan ng mga broadcaster ng Pilipinas. Ang mosunod nga programa binayran, bisan unsa nga hunahuna og opinyon nga malitok sa nagdumala niini, iya ra kini ug walay labot ang istasyon. Bisan ang baruganan nga ipadayag sa nagdumala sa mosunod nga programa, wa magpasabot nga mausab kini ang gibarugan sa tagdumala niini nga sibiyahan. Daghang salamat. Mga importanteng isgutanan may tungod sa balaod, negosyo, politika, ug bisan pa sa atong lifestyle. Oras na nga kita makig-uban sa duha ka mga aktibo ug batan-ong abogado nga sila si Attorney Ken Tamala ug Attorney Joff Namalata sa programang Lunch Break.
Mayong udto sa tanan. Welcome to our conversation.
Sa amihanang Mindanao.
So sa atong mga viewers diri sa Cagayan de Oro o Northern Mindanao, daghang kayong salamat for tuning in diri sa lunch break. It's been more or less 3 months na wala naka-air ta live because of the pandemic, and we are very glad na nakakuan ta diri karon, nakabalik ta, ug atong guest very knowledgeable aning subject. Makaingon gyud ta na eksperto si ani.
May nguto din na. Ay, good morning, Ken.
Good morning, Ray. Mayong
So,
buntag.
sama sa inyo kanina, it's good to be back here, no, sa to studio. So, the past few weeks, so, nag-recording ta dito sa atong law office. So, it's very, good. Nice feeling na naa din karon sa atong studio.
Murag taod-taod gyud to bay, murag after a long while, murag lisod dayon. Somehow at least murag sa ilang giingon na new normal. So mabalik na punta.
Balik ta. Kung karon pareha karon nakamas na kita kay mo may mando sa atong kuano sa gobyerno na to.
Butan kita.
So, so dindot kay atong tapos karon no? Kay medyo hot topic kini karon sa ato sa media karon na kaning katong na-bill na gipas, which is katong anti-terrorism bill. So, ang pinaka-last na akong nakuha, correct me if I'm wrong, murag naa na karon sa atong presidente for signing na. So, gipasa na sa Congress lugar. So,
Palit siguro introduce sa atong kuan, Joe.
okay. Atong guest karon, no? Isa siya ka Constitutional Law and Political Law Professor sa Xavier University. Dugay na kini siya na abogado, more than 10 years na. O classmate po namo siya ni Attorney Ken sa law school. Si Attorney Carlo Magno Calingin. Ay, sorry. Before pa diana, legal officer po siya sa Balaod, Mindanao Base, Dinis Cagayan de Oro. So, ladies and gentlemen, Attorney Carlo Magno Calingin.
Salamat, Ken. Salamat, Joff. To all televiewers, ako si Attorney Carlo Calingin. I've been teaching political and constitutional law at Xavier University for the past, I think, 8 years. And I'm presently connected with Balaod, Mindanao, which is an NGO. It is a non-governmental organization which is devoted to the advocacies of human rights, women and children protection, and environment protection.
So, maayong buntag again.
Good morning.
Good morning. Kanang he is also our fraternity brother. Muna yung among pinaka-bright sa among badge. So, munang ka-intimidate ko karon na diri karon. So, kanang Attorney Carl, kanang unsa man imo ang stand aning kuan anti-terror bill of 2020?
Kining anti-terror bill, it is designated sa Senate, murag Senate Bill number 1083. It was passed by the Senate, the House of Senate way back in March, and then it was in toto adopted by the House of Representatives, and then just recently, I think this week only, it was forwarded to Malacanang for the para mapirmahan sa atong presidente para mahimo na siyang balaod. Well, in context naman, especially here in Mindanao, di ba? we have always condemned terrorism. Terrorism is such a menace to society. It affects not just the community in which the terroristic attack happens, but it affects the entire country as a whole. And even in the whole world, terrorism has always been condemned. And there has been a lot of measures, legislative measures, passed in other countries and now here in the Philippines para masumpo kining terorismo. So, coming from that point of view, naani karon ang kuan ato Anti-Terrorism Act, the proposed Anti-Terrorism Act of 2020. The intention, I think the intention reading from the pronouncements of the senators and our congressmen, the intentions are good. They are for noble purposes para masumpo gyud. But we are apprehensive because many of the provisions in the proposed bill seems to contradict the provisions of the 1987 Constitution. Muna diya ang question nato.
So murag nindot kayo na Attorney Carl, okay lang ba na ato ng tinagsaon?
We will just focus on some salient points, di ba? For example, in the very definition of terrorism, giunsa nila pag-define kung unsa ka mahimong terorista, it is, naa siya sa Section 4, terrorism. It means that, it says here, paragraph A of Section 4, engages in acts intended to cause death or serious bodily injury to any person or endangers a person's life. Generic kayo siya pagka-define, di ba? If we try to examine the revised penal code, pwede siya mabilong sa crimes against persons. Also, in paragraph B, a person who engages in acts intended to cause extensive damage or destruction to a government or public facility, public place, or private property. So, under the revised penal code, pwede siya belong sa crimes against property. Now, there is an additional classification here. When the purpose of such act by its nature and context is to intimidate the general public or a segment thereof. So, mura siya babutang nato sa maybe it is a crime of rebellion or sedition, or pwede pod kudita. Now, this definition becomes vague vis-a-vis the other laws which punishes the same act, di ba? For example, there is a certain person who tries to burn another person's property tungod sa iyang kasuko, lugar kalagot sa ana nga tao. Di ba? Nasuko siya. So gusto niya nga iyan ng panimaslan, iyang sunugon iyahang balay. So that would fall under destructive arson under the revised penal code. But under paragraph B, cause extensive damage or destruction to government or public facility, public place or private property. So pwede na ka mahimong terorista. Even though your intention is only to destroy that person's property. And pwede man siya intimidate general public or a segment thereof. Kung sa may definition mo sa segment, pwede ba isa lang kapamilya imong hadlokon? Pila ba na sila katao, di ba? So there is an ambiguity and certain vagueness in which the proposed law has been couched. It is in general terms.
So you're saying, in short, Attorney Carl, na tungod sa kanang certain vagueness and katong ambiguity, pwede na susceptible to possible abuse at some future time.
Precisely. Precisely the point. Because as much as possible, the law should be specific so that the person who will enforce the law will have no leeway in enforcing it. It will leave no discretion on the person who will be enforcing the law. Kaya kung subject man gud siya sa different interpretations, pwede siya ma-overexpand so that it will be overreaching, and the powers that are intended to be granted, ma-overextend siya. Dako na kayo siya. Diba?
Dayon na ito'y gi-mention, Attorney Carl, kay kami, ato man yung tunan more or less the pros and the cons, naman sila giingon na kanadya after the enumeration of those acts, na gitawag diha na purposes. Na inaamay katong mga pro ani na nag-ingon na the purposes, kay technically ang terrorism based on Section 4, na ay acts na ay purposes. So ang purposes daw are specific enough daw. So to disabuse any possible kanang over-expanding of in the implementation of the law. Mo agree ka na?
Well, I think the definition and the qualification of the purpose or the intention of the act is quite ambiguous also. But it states here to intimidate the general public or segment thereof, create an atmosphere or spread a message of fear, to provoke or influence by intimidation the government or any of its international organizations, seriously destabilize or destroy fundamental political, economic, and social structures of the country, or create a public emergency, or seriously undermine public safety. Broad kayo siya, subject to different interpretations yun. Especially as lawyers, kuan mo base siya kung asa ang punto sa atong gidepinsaan, kung prosecution ba ta or accused, di ba? Pwede na to siya balihon.
Oh, so you're saying kung ikaw mo ay abusado lugar na simbako palayo na law enforcement kanang personnel, pwede nimo matuyok ang provisions in a way that will suit your interest.
Yes, precisely the point. Pwede siya mahimong a weapon, ma-weaponize nimo ang balaod to satisfy maybe political advancements or any self-interest.
Attorney Carl, na may contention no, ang uban katong sa pro lugar ani sa balaod. Ilang contention is kung wala kay intention na dautan, dili daw angay mabalaka. Unsa man imong opinion ana?
I think that is a very general and a very kuan siya, kining sweeping statement siya. Because if we try to examine the law vis-a-vis the Constitution, ang Constitution ko dili man siya mo kuan kining mo classify kung imong intention maayo. For as long as this is against the Constitution, bahala pag imong intention pinaka maayo sa tanan, still the law should be considered null and void because it runs contrary to the Constitution. So kanang punto nga moingon nga dili ang tao dili angay mahadlok kung dili ka terorista. I think it is the concern of all citizens to see to it that all laws that are passed by Congress is in accordance with the Constitution because the Constitution is our fundamental law of the land.
So, Attorney Carl, naaman diha gibutang sa first paragraph sa Section 4, di ba? At whatever stage of execution. So, technically, attempted, frustrated, or consummated, life imprisonment o automatically. So, unsa may mong masaya na?
Let us try to concretize the terms para masabtan sa atong mga viewers. For example, 3 persons come together in a conspiracy to commit an act of terrorism. So, nag-prepare sila. They tried to, ang ilang plano, manunog og mga bus, di ba? So, nag-prepare na sila. And then, one of the persons, while nag-atang sila sa bus ng ilang sunugon, he decided, na di na lang siya mudayon. Maybe because of his conscience, maybe he is bothered by, nahadlok siya nga magsapnan, anak. So, he left. Niyawa siya, wala siya ni padayon to pursue the criminal enterprise. But his 2 other conspirators, gipadayon sila na sunog. Nadakpan silang tulo. Even that person nga ni-atras na siya. Until that time, wala pa man siya na-commit nga crime if we base it on the revised penal code. But if we base it under the Anti-Terrorism Act, he will be punished for terrorism. The same as those persons nga actually ni-committed sa pagsunog. Although, katong person nga ni atras, wala na siya ni padayon. So you will be penalizing persons even though they are less guilty than the others. Diba?
So asa man naka posible na violation sa Constitution?
I think it is a violation of the due process and the equal protection clause. Because the due process and the equal protection clause of the Constitution is broad enough to cover those kinds of violations.
Dahil naamang po'y murag mga kanang pro lagi kay ato man
No,
yung
daghan,
grabe naman
daghan
kay
na.
ang pro ug ang anti ani na murag nagsago na ilang arguments. Niingon man sila na the reason daw possibly why the House and the Senate wrote the kanang particular phrase there
Yes.
na at any stage of the execution ug pareha ilang penalty is because of the seriousness and the gravity of the crime of terrorism. So regardless of asa ka na stage tungod kay hinus kanina crime, dapat gid ka i-posable o katong maximum penalty allowed by law. Unsa may maingon ang Attorney Carl?
There is no question that terrorism is really a grievous offense. It is a very grievous crime that has to be condemned. Pero base sa atong example, di ba, it would be, I think, unconstitutional for a person to be convicted if his or her participation in the actual commission of the offense is a lot lesser than the other people. If we try to base this on the revised penal code, which has been the existing criminal law of the Philippines for so many years, or decades now, there is always the attempted, frustrated, and the consummated stage. And the penalties for those stages are per grade. They are graded, di ba? One is lower than the other, depending on the participation.
With regard sa katong conspiracy bitaw, Attorney Carl, siyempre katong kwan sa pro lugar ani pro ani na balaod is malagi katuingon ni Attorney Ken na grave lagi kayo inana unya based sa tong revised penal code lugar ang kung conspiracy lamang gyud
The act of one is the act of all.
all. So unsa mi mong kanana base siguro ang kwan lagi ang seriousness sa crime kanang with regard sa conspiracy.
Yeah, as I have said, there is no question that terrorism is really serious. But we have to couch the penalties and the definition of the crimes in such a way that it would not run contrary to the due process clause and the equal protection clause.
Nindo to Attorney Carl kay imo nang na murag na himay-himay na buak nato ang kaning section 4. So naa pa bay laing murag provisions there na for that is alarming or worth looking into sa imong opinion?
I think one of the most divisive, we will say divisive kay murag the pros and cons are the people who are supporting it and those who are against it are really divided on this point. It is the provision authorizing the Anti-Terrorism Council to order the arrest of a person. If there is written order of the Anti-Terrorism Council, a suspect can be arrested without warrant, di ba? It is here in the Anti-Terrorism Act. And that person can be detained without charge for a period of 14 days, which can be extended for another 10 days, depending on the circumstances of the case. So, all in all, a person, a suspect, can be detained without charges for 24 days. And I think that is very foul and that is really contrary to the Constitution. In the first place, the Anti-Terrorism Council is not a court. It cannot issue warrants. Under the Constitution, it is clear that search warrant or warrant of arrest shall only be issued upon probable cause personally determined by the judge after examination under oath or affirmation of the witnesses or the complainant and particularly describing the place to be searched or the persons or things to be seized. Mo na ang naa sa atong Constitution under the Bill of Rights, di ba? But under the rules of court and because of jurisprudential mandate through the course of the development of our jurisprudence, the rules of court came up with 3 instances where warrantless arrests can be allowed. First is when a person is caught in flagrante delicto, meaning caught in the act. In cases of probable hot pursuit, when there is probable cause that the person has really committed a crime. And the third case is when a person is an escaped prisoner. Dili na kinahanglan sila nga musecure ang warrant so that under these instances, these people can be arrested. Now, the Anti-Terrorism Council, under this law, is given that power to arrest a person without warrant.
Contrary to the Constitution.
Yes, I think.
Oo.
Other lawyers think that it is not contrary to the Constitution, but personally, under my own understanding of the Constitution, yes, it is
So,
contrary to the
ato
Constitution.
lang buako ng attorney card. So you're saying na ay 2 points na with that particular provision.
Yes.
Your first point is
The arrest
the arrest without the authority supposedly
coming from the court.
from the court.
Yes.
Then number 2 is the
The
period of the arrest.
detention. The period of detention from which a person can be detained without charges, di ba?
So kanang period na 14 days plus 10, so in effect 24 days. Nganong for the information of those watching and listening, nganong man ang mura siya despicable kay na siya na kind of act. Unsa man na siya naaba na siya gi-violate na law, naaba na siya gi-violate na provision of the Constitution?
Well, I think that the provision of the Constitution that relates to this falls under the instances when the privilege of the writ of habeas corpus is suspended. That is a very extreme instance, di ba? Talagsaon lagi kina ay it happened in Mindanao, Marawi siege. In the very extreme instance, when the privilege of the writ of habeas corpus is suspended, a person who is arrested shall be brought to court and charged within 3 days. Now, that is under the Constitution, under extreme instances. Now, here comes a law which says, no, it does not apply because it is not rebellion or
Invasion.
there is no insurrection, there is no invasion. We can extend it to 14 days, even 24 days. Now, I think the principle that would apply to that is, if the Constitution, a certain act is not allowed to be done directly, you cannot do it indirectly. You cannot circumvent the provisions of the Constitution. And I think the 3 days that is given by provided for in the Constitution was thought of at the time the drafters of the Constitution made that provision. Ilang yun na una nga, 3 days is enough na yun.
May maximum yun.
Yes, yes, I think.
Para safety sa ano.
Yes. And for those who are advocating, supporting this 14-day detention without charges, they are citing other laws from other countries saying that Malaysia allows beyond 1 year of detention without charge, even Singapore, 3 years, Australia, and some other countries. I think it misses the point. Because I think we are an independent nation and we are bound by our Constitution. Although the other countries and UN mandates can apply by way of maybe just a comparison to our laws, we cannot close our eyes that these laws, in the first place, should be referred back to the Constitution.
So muog yun ay basis tanan.
Yes, yes.
Bottom line.
Yes, that is
Naka-mention na mag-attorney Carl sa Anti-Terrorism Council. With regard sa, unsa mong comment with regard atong sa designation lugar sa organization as kuan? Kung kanda na siya.
The Anti-Terrorism Council as created under the Anti-Terrorism Act of 2020 is a very powerful council. In the first place, under Section 25, they can designate or determine whether or not an organization is a terrorist organization or not. Contrary to the Human Security Act of 2007, the old anti-terror law of the Philippines, now it should be a judicial function. Although under Section 26, there is still the proscription that is done by judicial function, which is now under the Court of Appeals. Section 25 is very clear. The Anti-Terrorism Council can designate a person or an organization as terrorist. And it ends there. The power is granted with no qualification. So, we will be faced with a reality, if this law is passed, that there will be 2 modes of designating an organization or person as terrorist. One is judicial, the other is executive or administrative. And under the executive or administrative way of the determining whether an organization is terrorist or not, there is no relief provided. Di man mo ma-challenge. I don't know if I have read it thoroughly, but as far as I've understood it, wala may recourse ana once you are designated. So, going there on that thought, expanding it, what is the effect if a certain organization is tagged as terrorist? So what? Automatic, the members will be terrorists. And membership in a terrorist organization is penalized under this code. Life imprisonment. Diba? By mere membership, for example, our fraternity would be designated as a terrorist organization, kita ng mga membro, automatic terrorist na ta.
So asa man kana na act di ba na imo naman kay na mention na designation by ATC and proscription by CA. So asa man ang murag especially na ato mag-emphasize ang designation by ATC. So unsa man na sa attorney kan violate po na sa constitution in a way?
I think because it overspans the power of the council and it encroaches on the powers of judicial prerogative. Because previously it is a power only held by the court.
And
So
here
if
comes
you
this
try to
council,
appropriate to an executive branch, I assume it is an executive branch because all the members there are members of the executive department. Yes, it will be unconstitutional. I think.
So sa aside sa ana na provision on designation and proscription, apa ba kay laing murag provisions diha sa SB 1083 Attorney Carl na murag reprehensible for you na or alarming man lang?
Yeah, there are other provisions, but first I want to go back there to section 25 and 26, the prescription. I think the prescription of terrorist organization provided in section 26 is constitutional. It should be there. It is the proper way of designating an individual or an organization as terrorist. I think section 25 is unconstitutional because it allocates judicial powers to an executive department, to a branch of the executive department. Now, for other sections which I think is susceptible to abuse and because of its and ambiguous, I would like to refer you to section 9, inciting to commit terrorism. This is also a very contentious. This has been attacked by progressive groups. Activists do not want this section precisely because it says that without taking any direct part in the commission of terrorism shall incite others to the execution of any of the acts specified in section 4 hereof by means of speeches, proclamations, writings, emblems, banners, or other representations, which I think would run contrary to the Bill of Rights provision, which provides for the freedom of the press and freedom of expression.
Pero naa may nag-ingon Attorney Carl kaning mga pro ato lang i-contradict
Yes,
para
yes,
lang
yes,
para lang
yeah.
ma-emphasize
I am also well aware of the
para ma-emphasize. So naman sila nag-ingon na di ba nag-violate na sa katong right to free expression of the press. Pero na may pros na nag-ingon na somehow restrictive man kaayo, limited man ang definition of dili ta ma-alarm anang inciting to terrorism kay somehow ang definition lagi daw klaro man daw, di ba? Without participating in the act, plus ikaduha through speech, publication, and etc., you incite others to do the acts na na-added to na specify sa section 4 plus katong purposes. So dapat dili lang ang act imong i-incite, but practically you will also have the purpose mentioned in section 4.
Now again, that is our thinking. But we do not know how the enforcers of the law will interpret it, di ba? In the definition of terrorism, of course, they included it, that acts of protest rallies are not included. Of course, they are not included under the definition of terrorism But they can all fall under Section 9, which is inciting to commit terrorism.
So bottom line,
Which could produce a chilling effect on the exercise of the freedom of expression.
So in short, an Attorney Carl, is ang violation is kanang freedom of expression. So kana siya for particular na kuan.
Yes, if we just try to read it, maybe we can interpret any other way, but that kind of interpretation, if it is susceptible to 2, 3, or more interpretations, that should not be allowed in the law.
so
Because that gives discretion to the police and other enforcement of agents of the state.
so kani siya susceptible to abuse more or less.
Yes, I think.
Mm.
Yes, I think.
Look,
With regard sa katong na may interesting ani na provision with Attorney Carl katong with regard na katong magtabang ka sa terrorist. Oh, unsay mo comment ana?
I think Section 6, planning, training, preparing, and facilitating, if this is what you are referring to. I think this is also very vague because preparation could be innocent acts, di ba? For example, I've raised this example before in my one of my talks regarding this topic. Ang tao nagpalit og cellphone. And that cellphone happens to be the old model. Dili siya, walay camera, simple lang siya, tawag text lang. Palit siya, niagi siya checkpoint, kita nga na bago cellphone, he can be suspected as a terrorist in the preparation stage. Why? Because these old cell phones are favorite detonating devices for use in improvised explosive devices, di ba? Mo man ang gamiton karaan nga cellphone because according to the AFP, these cell phones di kusog mo kuhag signal. So balag layo pwede nimo ma-trigger. Dugay pod siya malubat, so you can plant it there 2-3 days, still you can detonate it. So that is a very innocent act. But based on this, Section 6, preparation, pwede na ka ma-accuse. Di ba? If we will try to expand the application of this, of course, maybe it is not the intention, but if we read the law, it can cover those kind of innocent instances. So, kinsa may terorista karon, practically anybody.
Even if innocent ra kayo
Pwede
mga
na, yeah.
So
Pwede na.
yung article is kanina sa the provision is susceptible to
Yes, abuse.
abuse.
And because it is ambiguous.
Napabaylain provisions, Attorney Carl, na murag for you alarming and worth mentioning here.
I would just like to reiterate the power granted to the Anti-Terrorism Council to order the arrest of a person on mere suspicion. Suspect pa lang, di ba? Pwede na ka i-arrest. Suspect pa lang ka, or the organization, it can already be tagged as a terrorist organization. So practically, anybody can be suspect. If there is a bombing incident and you happen to be there, nakuha lugar ka sa CCTV camera, and it happened duol-duol dito naa ka, you're not doing anything. Unsa may tawag ani under present parlance sa police, persons of interest. Di ba? But if this law is passed, you can be a suspect already and you can be arrested, detained for 14 up to 24 days without charge. What if it happens that you did really nothing? You have already suffered the consequences. You have already been detained and deprived of your liberty. And the provision of paying a penalty, which was present under the Human Security Act, katong magbayad og 500,000 per day for wrongful detention, was abolished in this law. Well, I think 500,000 is too much also. That's why the Human Security Act was not utilized by the police, it was not utilized by the armed forces. It was not a favorite law to be utilized by the prosecution services of our country because of that. Maybe the penalty can be lowered.
Dayon, you mentioned man, Attorney Carl, about Human Security Act. Then, effectively, once this proposed act is signed by the President, this becomes the existing law.
Yeah, it repeals the Human Security Act.
So, considering those against, na ay mga against ani kay ambiguous, fluid, and kind of vague ang provisions.
Yes.
So, unsa man gyud day ang mas ideal nato karon na situation? Do we want the law? We don't want the law to be passed. So, are we contented with Human Security Act as the existing law?
No, the Human Security Act is a very watered down law that it is not effective at all, the way I saw it. I think the good move for the President now is to veto the law and to ask for a revisiting or revision of the provisions of the
Human
proposed
Security
bill.
Act. Of
Ano
this
proposed
proposed
bill?
bill,
Because
oo.
admittedly, we need a stronger anti-terrorism law, but not this kind of a law which is very prone to
Abuse.
abuse and it creates overreaching powers for the executive.
Attorney Carl, with regards sa kaning Anti-Terrorism Act, no, is there some provision lugar which you think na maayo gyapon siya lugar gyapon?
Well, I have said that the provision relating to the detention of persons suspected as terrorists, 14 days, extendable by another 10 days, I think it is unconstitutional. If we see it in the context of a Filipino citizen. But we all know that there are foreign terrorists here in the country. And I personally believe that this provision can be modified so that it can apply only to foreign terrorists, which I think would be very effective because I've read one comment by one member of the House of Representatives. She was saying that there was a certain bombing in in Hulosulu, which was done by alleged Indonesian terrorists. And prior to that, maybe a week before the bombing, those Indonesian terrorists were flagged down upon entry to the country, but there was nothing against them. Wala may ebidensya nga terorista sila, but they were suspected already at that point. If this law is passed, and it applies only to foreign terrorists, it could have been prevented. Diba? But only applying to foreign terrorists. Because the provisions of the Bill of Rights, it guarantees the rights given to Filipino citizens. Kanang mga foreigners, they are not covered by the Bill of Rights. So I think it can be made applicable to them.
So, Attorney Carl, murag nindot pag yun unta gyud kayo na ato paning patason siguro pero paspas kayo ang oras. So, before lang siguro nato i-end kanang na kay few parting words or message to our viewers and listeners about this law.
Yes, to all our viewers and listeners, thank you for staying with us. And before we part, I think that it is very important for us not only to read the law or the proposed bill, but also to read the Constitution itself, the 1987 Constitution. Because we can only judge the law, whether it's valid or not, if we have read the Constitution. Because there are certain calls, bago ka mag-discriminate, mag-propose na you are against it, you have to read it. And I also say that before you support it, you have to read it also, and read the Constitution. Even maski just only the Bill of Rights. It is time for all citizens of the Philippines to be one in being vigilant in protecting our rights, because I think the proposed law as crafted could in the future invade rights granted by the Constitution. Thank you.
So daghang kayong salamat, Attorney Carl. Kabalo man gyud mi na you are busy kayo, and especially pag yung karon na COVID and you took the time to be with us today. So from the bottom of our heart, salamat kay very exciting
Salamat
discussion.
kay Kwan pod. Daghan kita na natun-an karon sa Kwan. Especially na ang atong guest karon is a well-respected na constitutional law and political law professor sa Xavier University.
One of the best legal minds in this part of the world, lugar, di ba, Colonel? Kaya tinood mo na, dili mo na pasakay. So, sa among mga viewers siguro, daghan yung kayong salamat, and it's good to be back after 3 long months.
3 long months. So,
Mauna siguro, Jo.
So that is our, again, Attorney Carl, salamat sa pagtambong. So that is our show for today. Thank you for watching and see you next week for another episode of Lunch Break.
Ni mover est kimondom nan redat meliore. What man is a man who does not make the world better. Maayong udto, ladies and gentlemen. Maayong buntag. See you next week.
Happy Independence Day.
Happy Independence Day.